play these games of getting out of jail, so I'm just gonna say something.
No, Your Honor.
Well, that's what you just told me. Only reason I pled, because I just want to get out of jail fast. I just want to be done because I didn't do it. That's what you just said. Whereas you have a probation violation on a driving while intoxicated charge, the maximum penalty on that charge could be up to 93 days in jail. You certainly have a right to have a violation hearing with a lawyer to represent you. Couldn't afford a lawyer, the court would have a lawyer appointed for you for the hearing. At the hearing, the burden of proof would be on the probation department. They would have, through the prosecution, and the prosecution would have to prove by what we call the preponderance of the evidence. That means the greater weight of the evidence would have to convince me that you're in violation in the manner being claimed. So if you have a hearing and you're found guilty of the violation, or if you waive the hearing to plead guilty, in those instances, you could be sentenced to the maximum penalty. You understand that? All right, so the violation alleged here goes back to February 5th, 2016. Failed to pay balance of fines and costs at that time was $2,775. It's now $3,022. Failed to provide proof of treatment and AA meetings, failed to submit to random testing, failed to attend the driver intervention program, and failed to provide proof of 80 hours of community service work. So those are the allegations from back in 2016. So you may choose to have a hearing if you like, or you can waive your right to the hearing and plead guilty to the violation, or you could speak to a lawyer if you don't know how you might proceed.
I just got one question. This gentleman told me I could plead for 15 days.
What gentleman? So, the court officer / counsel over there told you that?
Yeah.
Well,
and I was gonna say
he's right to an extent. You can plead, but I don't know anything about 15 days.
Oh, because I was gonna say I already had.
Because the maximum penalty could be up to, 93 days maximum.
Right.
The recommendation says 30 days, credit for 14. That's what probation is suggesting, and to terminate your probation. You're not going anywhere anyway.
But I'd rather speak to the attorney.
Okay, we can.
Yeah, with my plea, I'm sorry, but I thought I was plea to get sentenced today too as well, so I'd rather take that plea back.
You want to take a plea back?
The one for, because I thought I was gonna be like get probation, start probation today.
Sir, on all domestic violence charges, we get pre-sentence reports. You don't get sentenced the same day.
I'm sorry, I didn't know.
She might not have known that, but what difference does it make? Either you want to plea or you don't.
I don't want to plead guilty to it. I just do it. I was just trying to plead guilty to it to get out of jail.
Sir, you not getting out of jail because you have a felony. You gonna be here anyway till January. How you going somewhere? You have a bond that you haven't posted. Now, if you post the bond, you can get out on the felony.
Right. Well, I have to post the bond, but the misdemeanor too as well.
Right now, on the violation of probation, you don't have a, well, I don't know what the bond is. They did arraign you. It's $3,500 cash and surety. So it's gonna be that until we resolve it. On the other matter, whatever the bond is, you would have to post that and to get out to do the pre-sentence report.
Right, okay. Well, I want to take my plea back.
You can't take your plea back. Your lawyer's gone.
Okay.
She left.
Okay.
So if you want to contact her and say,
she told me something different, so that's.
sir, let me tell you this. I'm not in the habit of accepting pleas for people that want to just get out of the system faster. It's either you did it and you want to plead, or you didn't do it and you don't want to plead. And you want. I don't play these games of getting out of jail, so I'm just gonna say something.
No, Your Honor.
Well, that's what you just told me. Only reason I pled because I just want to get out of jail fast. I just want to be done because I didn't do it. That's what you just said. But try it.
I mean, Your Honor.
I don't play with the system like that. The system is serious.
Very serious, Your Honor. But also, I'm in a situation to where I'm about to lose everything. So I was just
well, sir, I don't have anything to do with that.
No, I know. Okay.
Whatever did or didn't have to do with you and this lady is the problem.
Right.
And not only one incident, which is domestic violence that you took a plea on, but you got a felony pending. Whether you did that, I don't know, but that's set for preliminary examination.
Right.
In January. So I'm not sure if you're gonna lose something, but you're gonna have to find a bail bondsman to post your bonds then. If you wanna get out,
Okay.
because you don't come back on your cases. That's the problem.
Well, Your Honor, just to be honest with you, I'm a 40-year-old man. I'm not a child anymore. I'm taking care of my daughter, my 100-year-old father. Like I said, I was just trying to plead so I can get back to get that situation.
Well, I'll tell you what, best we can do for you is call your lawyer back and tell her to call you. And if she wants to reset this matter and she wants you to withdraw your plea, then we can certainly rearrange to have you come in next week or something. But right now, you can't do that because you have a lawyer.
Okay, okay, I'm sorry to waste your time.
What do you want to do with this violation?
I want to get an attorney to that.
Okay, so let's pass this and have you fill out a court-appointed attorney
I know
form.
what Your Honor, I just need to.
Well, wait, sir, no, wait a minute, you just bouncing all over the place.
I know, I'm sorry, it's just, I've been.
No, you're making rash decisions, you're not thinking. So either you want a lawyer because you want to figure out what you want to do on this violation, or you don't.
It's gonna keep prolonging this stuff, right? It's just.
Well, first of all, you're gonna get, if you've been in custody and if you do get a jail sentence, you're gonna get credit for all of the time anyway. Because you haven't posted the bond. The only time you don't get credit is if you post a bond. So you're gonna get credit. If you want to talk to a lawyer, we can try to set this quickly and get a lawyer appointed for you. Right now, you got 14 days credit. So if we come back next week, that's another 7. That's 21 days that you have for credit. Either way, you're getting credit if you get a jail sentence.
Right, okay.
So do you want to talk to a lawyer or not?
No, I don't talk.
So what do you want to do? So the choices are not guilty with a hearing, or guilty, or lawyer. And you can have a lawyer for the plea if you want one.
I get the lawyer.
Okay, so we're gonna have you fill out a court-appointed attorney form, and Mark will get it for you. And then once you fill it out, we'll recall your matter. We're calling it under John. Okay. All right.
2,000 years later.
So it's true then that you did test positive for alcohol on November 2nd with a 1,081 ETG, and then you got it confirmed with the ETS test 291. So that's correct?
Yes, Judge, she did indicate to me that it was.
I'm asking her,
Oh,
she's the
sorry.
one pleading. Is that correct?
Yes.
All right, and then failed to appear for a test on November 6th for ETG, is that correct as well?
Yes.
And then apparently they've indicated it failed to appear November 15th, 17th, 27th, and December 12th, is that right too?
I don't recall, but yes.
Okay. All right, well, I find that's sufficient basis for this plea, and I'll accept it, finding that plea is freely, understanding, voluntary, and knowingly made. What would you like to say?
Your Honor, as indicated by Ms. Webster, it seems to have been a transportation issue. She did indicate
You
that
can't have that.
I completely agree. I did go over everything with her, and I did advise her that if she were to have a scram tether, it would be a continuation of monitoring the alcohol levels, and that way she would not have to worry about transportation. Her father is in the court with her today for support. He has indicated that he is a supervisor, and he would often take off work to take her to and from testing. Today, she is going to Common Ground Rehab to address those issues. So we respectfully request that you follow the recommendation from probation for the scram tether, because Ms. Webster is also in agreement with that.
People wish to be heard.
Absolutely, Your Honor. Last time we were here, Your Honor, for violation hearing was that sentencing date back on September 26, 23. Sister counsel was not here, the law counsel was here. Specifically, I'm reading from my notes that the court did sentence the defendant 18 months probation, 21 days jail credit. 21 days jail credit for 1, 17 days held in advance. The defendant was supposed to complete 3 days of community service, outpatient substance abuse treatment. The entire time while this case has been pending, Your Honor, we had several missed tests and violations that are ongoing.
Oh, yeah, I see.
And you were pretty darn clear that any positive tests, specific positive tests, that you're gonna give her the minimum of 17 days in jail. And I would ask the court to hold to its word, because you were pretty clear. And here we are today. Let's put aside the missed test. Let's say that has been an issue, and I'm not arguing, could have been. Or what about the positive test, which is confirmed? There's been no accountability, there's no responsibility here, it's ongoing issues here. I don't think Ms. Webster realized that she cannot drink while on probation. Has been doing so since August. Actually, since July. The entire time, actually, take it back, since June. There's been ongoing bond violations, ongoing positive tests, ongoing missed tests. We can't just keep looking the other way on it. We need to keep the community safe. So I would ask the court to impose 17 days jail sanction that the court had promised last year.
If I may, Your Honor, in response.
I said it. It's an alternative symptom. She knew it. I told her. I said, well, 21 days credit for 1. 3 of those jail days would be an impact weekend. 17 of those days would be suspended if she's in compliance. She hadn't been able to go. What would you like to say?
Your Honor, she fully accepts responsibility.
Good. Was she ready to go?
Judges got
Where else would she be going? Jail on 17 days.
Your Honor, she just really requests that you give her another chance. She agrees with the recommendation of probation for the scram tether. She is willing to do that. She has accepted responsibility. She is even going to rehab today to address those alcohol issues. It was scheduled for her to go in this morning, but because of this hearing, she adjourned it to a later time today to be checking in. She is actively trying to address those alcohol.
I like the fact that she's enrolling into a program.
Yeah.
I do like that, but I still said what I said. So how am I gonna balance the two? Because she don't have to do 17 days, whether she goes today or whether she goes when she gets out.
Judge, if I may, maybe you can have her enroll with the scram tether, and if within those 60 days, she, violates and tests positive again, you can hold her in terms of sentence for those 17 days again. But she will be entering into rehab today, and she does acknowledge that it was a transportation issue.
I don't care about transportation issues because she got 2 legs
Right, Judge.
and she could walk. She could ride a bike.
I explained.
She could call a friend.
Right.
It's just too many ways to get around. People do what they want when they want to. This is a party. I'm sure she could get there. This just happens to be testing, so it's hard because it's testing. But people do what they want. And if I had to face somebody that's got my jail sentence over my head, I would make sure I'm getting there some kind of way.
I agree, Judge, yes. If I may, she just respectfully requests that you show me safe.
I did. That gave her no direct jail the first time.
Right.
And this is a high BAC case. Let me see what.
0.21, Your Honor.
Yeah, 0.21. I was about to see what it was. So, I applaud her for finally deciding she needed to do something. But, the prosecution was right to a large extent too, that throughout the whole test, this whole case has been hundreds, it looks like, but I'm sure it's not hundreds, but it just looks like it. No show after no show after no show after no show. And I never did anything. Because I kept saying, well, let's give her a chance. Now you ask me again. Nope, my goodwill's gone out. She'll do 17 days in Oakland County Jail, no credit. Then she will enroll in Common Ground Rehab after she's released. $100 violation cost she'll pay. And she'll get a scram tether within 24 hours of release from jail. That's the sentence of the court.